Hey guys, it's Kathy. I hope you guys are doing well. I am. It's a nice Sunday. Gosh, it's 7 a.m. already. So I'm a little late. But it took a while. It took a while to get anything. It's the weekend, you gotta work extra hard. The very first clip I have is only a few minutes long, which I thought I showed you guys last stream, but I double checked and I didn't. Um, but it's only a few minutes long. If I showed it before, it's good enough. I have the whole case. I'm only showing you a small clip. The whole case isn't as exciting as this one part. So I'm only showing the one part here, but I will put the whole case up on the members only side if you wanted to see it. It's not as exciting. It's just not. It ends as you expect it to end. So that's all I'll say about that. And here we go. Let's go.
Stop talking. You're ordered to stop talking. 5th time. If you would like to leave this courtroom,
No.
you are more than welcome to leave the courtroom.
I don't understand what that means.
I'm going to just hold you in contempt of court.
I don't understand what that means. I'm telling you, I don't know what waiving.
Do you not understand when I say be quiet?
Means.
You're ordered. Listen to one sentence.
Sir,
Listen.
I'm trying to
Listen. Stop talking. You're ordered to stop talking.
It's fucking unbelievable, man.
I'm going to identify on the record, I am Judge Christopher Spataro, and this cause being heard is 2310 EV 1670. I have ordered defendant Leandra Kraft to stop talking and stop interrupting proceedings on numerous occasions. Before the trial even started, I gave admonishments because I anticipated there might be interruptions in testimony. Notwithstanding that order to refrain from making comments during the proceedings, Ms. Kraft proceeded to make audible noises on multiple occasions. When I stopped the testimony of the plaintiff's representative and asked her to be quiet, she continued to talk. And now she's even continuing to talk right now while I'm making this record on her contempt of court. So therefore, she has delayed my... Ma'am, you're ordered to stop talking while I make this record on your contempt. Do not make any additional noise, please.
Please, for fucking one system.
I find that this conduct was done in defiance and disrespect of the court and against the dignity of the court and against the law, and it certainly interrupted these proceedings. The disturbances is that we've now had a significant delay in these proceedings. I can't listen to this witness testify over the noises made by Ms. Kraft. I'm going to give Ms. Kraft the opportunity right now to apologize to the court for her behavior and promise to correct her behavior. She has one opportunity to do so. If she would like to take advantage of it, I will not hold her in contempt of court and jail her. If she does not want to take advantage of this opportunity, I will call security and have her removed from the courtroom. Ms. Kraft, would you like to apologize and promise the court that you will not act as you have for the first 10 minutes of this proceeding?
Yes, sir.
Okay.
Sorry.
I accept your apology.
Yep.
I will not hold you in contempt, provided that from this point forward, when I am in the middle of a sentence, you do not interrupt me. You're ordered not to interrupt me. You are also ordered not to interrupt the testimony of any witness, even if you disagree with it. That's not the way the proceedings work. I am speaking in plain English. If you don't understand that you are not to talk in the middle of my sentence, then you have a problem. Please don't talk. I'm not done. I am not done. Okay. I'm going to allow Mr. Patel to continue to give testimony. If I hear so much as a sigh out of you, I'm going to have you jailed. Do you understand that, ma'am?
Okay.
Thank you. End of, no, you, if you would like, ma'am, I've now answered that question. Shut up long enough to listen. I'm going to answer your question. You have every right to go and sit in the hallway during these proceedings so that you don't have to listen to the testimony with which you disagree. However, if you do that, you will waive the opportunity to object. That means if there's something that is wrong, some rule of evidence that's not followed, you don't have the chance to say, Judge, I object for this legal reason. So that being said, if you would like to sit outside, just do it right now so that we can get on with these proceedings. I'll give you 5 seconds to leave or stay. 1, 2, 3, 4, 5. Since you have not left, I assume you want to stay, and I assume that means you will follow the rules in my courtroom. Be quiet from now on unless you're asked a question. Mr. McCaslin, you may continue with your questioning.
Can I have the reporter read back the last question?
No, the reporter was not able to read back the last question because there is no stenographer in courts anymore. It's this. They record it like this. So so he had to figure out where he was all on his own. Uh, so just an overview of this case. They live in a hotel. These two right here, they live in a hotel, and they stopped paying in 2022, I think. They stopped paying for their room, and she claims that she works there, so she gets the room, because he's never given her any paychecks at all, and her pay outweighs the rent. So in her mind, she has credit until 2025 or something silly like that. So they just don't. They're just living there now. She doesn't work there anymore, and they don't pay, and so they're in court for that. There's a whole lot of problems with both sides. Like, how do you just not pay someone? There's no written contract, whatever. This judge was great. He handled it superb. This next one, what would you do if you were this judge?
That's it for us.
Ms. Burtis, before you hang up, I had one thing that I wanted to raise before the court.
Yeah.
Does it involve a felony case?
It does not, Your Honor. There was a
I have no
motion that was filed that is rather time sensitive, and I wasn't aware that Judge Zirip was out today, but it's on Hector Huerta, case 23M 285, and I just bring that up because it's somewhat time sensitive, and I wonder if the court may be able to take a look at it.
Unfortunately, the answer is no. I have a hearing in about 15 minutes. There's a motion pending. Are you going to respond to it, Ms. Burtis?
I think that the district attorney's position is listed in the motion. I think it's a.
What is it? Is it opposed? Is it a?
No, I don't believe it's opposed.
Yep, it is. Mr. Allen spoke with defense, and we don't oppose at least the motion,
Right.
joint motion to close the case. Yeah.
I'm sorry, folks. I'm not really following what there's a pending motion. The people are not opposed to it. And so it's a motion.
And it would would result in the person being released. That's why we're bringing it up now.
Well, folks, it's not in front of me, and I'm not sure I'm going to even look at it. So if I need to get another judge to step in and look at it, tell me what the motion's for. What is it?
Your Honor, it is a motion essentially granting the individual credit for time served for they are in custody and have served the maximum sentence on a public service complaint. They've served beyond the maximum sentence.
Was the motion filed before yesterday?
I'm not sure what date.
So Judge Zirip has not seen it.
No.
Counsel, I'm just really reluctant to address any case that's not sent to me covering for Judge Zirip. So if it's in front of Judge Zirip, I'll have Sherry see if he can either address it or whether another judge needs to step in and do something, right? My understanding though, Ms. Burtis, is that the people are not opposed to the request. Is it a situation where he was ordered to do like 30 hours of use of public service and then got 30 days of jail for it?
It's 10. It's believe it's a petty offense.
Yes.
It's a petty offense. It's a disorderly conduct, and at this point, he's been held beyond that.
Beyond the 10 days?
Mm-hmm. So, I understand the court's position if Judge Zirip can be contacted or a different judge can handle it.
Ms. Apatow, it's not my case and I have no jurisdiction over it. I understand you would like me to address it, but I'm not willing to do that unless I get permission to do it. So just because I'm covering advisements today for the county court doesn't mean I'm sitting as the county court.
I understand, Your Honor. I can assure the court that if it were Judge Zirip that we're sitting here today, I would be making the same request of Judge Zirip.
I gotcha.
It's not in any way, shape, or form requesting things to go to certain courts. It's just that it does affect whether he can be released.
And he's done as of today. Otherwise, he's going to stay in custody through at least Monday, it sounds like.
That's correct. And I will tell the court that he has another case, but he can bond in the other case. That's the problem. he's being held on a different case, but he can bond in the other case. So it does directly affect whether he'd be able to get out.
Now it sounds even more complicated than it did before.
It's
Ms. Burtis,
not, it's the
just
same
so-
thing.
We're not even on the record, folks, so just so you understand, the people are not opposed to this, but have you filed a response indicating you're not opposed to it?
We didn't file a response, but the motion is joint and it does indicate that we are not opposed.
Okay. Do you have a case number?
Yes, Your Honor, it's 23M285.
All right, I'll have Mia let Sherry know and we can see if they get a hold of Judge Zierup. Folks, again, I appreciate that there's an agreement here. It's just not my case, and I am very reluctant to interfere in another judge's case unless I'm covering that case for him. I have no idea what Judge Zierup would do in that situation, nor has he asked me to cover it for him. So it's not a situation where the court feels comfortable just saying, I'm going to do it, and tough. See if you can reach out to Judge Zierup. If he can't do it, see if there's someone else. Otherwise, bring it back to me. Okay? All right. Thank you, Ms. Burtis. Thank you, Ms. Apatow.
Thank you.
So at the very end, he's like, otherwise, bring it back to me. Because he actually can take care of it. He's pro tem. He actually can take care of today's court business. Now, I remember when Judge Giles was going on vacation, it was painstaking what he did to set the judge up who was going to cover him for those days. He knew exactly what cases on exactly what days were going in front of that judge. And, yeah, I mean, you guys seen enough court cases to know that when the lawyers are in there, they ask for continuances and they ask for specific days, and it's so hard to get their calendars right, especially in Detroit. And Giles was he just was adamant. No, you're not getting that date. I'm out on vacation. It's going to be a pro temp judge, and I don't care what's going on. You're not getting these dates. You're just not. So they do try very hard to only put certain cases in front of pro tems. But a lot of the pro tems, they take, who's in the jail for first appearances and things like that. And that's not pre-planned. And he is in that seat, and he does have the authority, and he can take care of this. He's right that he shouldn't just take a case that's not on his load. But it's such a petty one, and if you follow the law, this guy should not be in jail anymore. That's a big deal. His freedom is a big deal. It's a bigger deal than him, maybe stepping on another judge's toes a little bit. This guy's going to get 3 extra days of jail. Or 2. I don't know if the courts are open on Monday. Tomorrow. I can't remember. But, okay. Let's move on to the next one where, you mess around and you find out. See, I don't want to get demonetized. So I had to sugarcoat that.
Almost FTA'd you, but glad you're here. Come on up. This is 23 CR 1752.
McKenna Mayfield for the people.
And Mr. Roscoe-Rubin, you are not represented by a lawyer at this time, right?
Right, and I've been trying to get my information with the public defenders, and they said they've been having troubles with their internet or something.
Yeah.
And so I have screenshots of the multiple emails I've sent, because I've tried 3 different emails to contact them too. So
their systems are just completely down right now, so
okay.
I'm not surprised that you're finding that out. Were you saying that you've applied but you can't check the status?
Yeah, and then I currently lost my job a couple weeks ago, so been trying to.
Mr. G. Taylor squeezing out the door just in time. Mr. Gardetto left holding the bag. Are you guys able to check status of applications?
So Judge, we're in a difficult position because all the applications that we had previously received and scanned into our server, we cannot access. And so what I've been advising people to do, fill out another application, continue to follow up. I understand it's not convenient.
I know you can't hear him, I know you can't hear him. I know the audio is bad, but it doesn't matter what he's saying. He's just going to talk for another minute, and then the good stuff comes.
If you do have transportation, my advice would be drive to that office today, fill it out again, and then
In person instead of online.
basically after that point, if there's proof of income or something, you can send that to the email.
Well, and that's the hard part is because that's what I did the very first time in the beginning, and then it somehow still didn't. And that's what kind of held me back the first time, and then I just felt defeated. And then so I've really been pushing to do it forward, but it's still like even when I did the application in person, they wanted all of the email stuff, and so I could still go and try, but it's pretty much the same thing that I'm doing at home.
Do you have reliable transportation?
No, that's why I keep being late. I'm like, I'm sorry.
What I can do is I can have you fill out another one right now. I can bring it back to the office and then just keep following up and bugging them because we're just trying to process the backlog.
Okay, and that's the hard part too, is because like with my income, like even when they with the like they didn't give me like a professional like they just sent me like a text message explaining why they were letting me go, and then also for my wages like my previous employer had like an ADP or something that you could see that where it's just like a bank statement from the job. So I just took the screenshots of the bank statement from the company's name, and that was the last like 3 pay stubs I had, and so I don't know if that's enough either, but I have the screenshots.
So let me have the two of you have this conversation.
Okay, sorry.
On your own. It sounds like there's a plan where Mr. Gardetto's okay with taking an application that you'll fill out today back to his office.
Yes. Okay.
Frankly, the bigger concern that I have is with bond.
Okay. Well, and so
wait. I want you to not talk right now because what I need to tell you is that I think we had a conversation about bond and UAs the last time, and it doesn't seem like it's gotten better. And I specifically want to let you know that you don't have to respond to this right now because I think that we're in a place where there might be a charge. And so that's why I want to protect your right to silence. Ms. Mayfield, what do you want to do with respect to bond today?
I simply did not have a chance to file a motion to revoke bond. I am going to ask the court to do so today. If the court would prefer I file something, I can do that. But I will note that Ms. Oroso has been told at 2 prior court dates to report to CJS and get back into compliance. At the last court date, she appeared at 11 o'clock. There was a warrant issue that had to be quashed. I'm really understanding the other issues going on in her life. I'm really concerned that she is not taking this seriously, particularly with the allegations here. We have missed test after missed test after missed test with some positive. I'm concerned for community safety as well. So that's my position. I can put it in writing if the court requires it, but I think that at this point I would ask to revoke bond.
I will ask you to follow up with a motion in writing just so that we have a clearer record, but the court agrees that you have demonstrated the violation of bond adequately that the court needs to revoke. So Ms. Orozco-Rippin, what that means is that I need to take you into custody today. Hold on one second. Ms. Mayfield, do we need VRA before we can address a new bond, or can I address a new bond under the circumstances?
VRA, victims' rights. So they can't address a new bond if there's a victim because they have to talk to the victim first.
I do need to VRA. It's a all case.
Okay. Am I allowed just to say one thing? I know it doesn't change anything, but just to say one thing.
So you certainly can.
Okay.
Given that it doesn't change anything, I don't know that it's necessarily in your best interest. I know we had to talk about this the last time, and
I know
Ms. Mayfield's right that I have to do this now.
And I know, no, that's right. And it's hard because the person that I've been talking to with getting the funds, because that was going to help me, she told me she was calling me at 9 a.m. the next day. She calls me at noon as I'm going into work.
So
I tried to contact her and she was sorry. So, and I'm not trying to make excuses
we're not having a one-time problem that relates to funding though. We're having an ongoing problem that relates to sort of what CJS says is minimal compliance.
I'm begging for I literally have been getting, and it does not look like it to you guys, but I literally have been getting these steps all together and making them
Literally.
work. And I'm literally,
Literally.
I know for a fact that I will be in and taking my UAs right away. I'm not just making any excuse. I literally have been finally getting things lined up because I'm about to lose my housing. And so I was close to, I'm hoping that I am getting this loan right now. But I'm telling you, it might not look like it to you guys, but inside I know that I am prioritizing it, and it doesn't seem like it right now, but I don't want to make excuses, but I really know that this month is really going to be changed. And even if I have to get bonded out and do it, I know what I'm doing and how everything's coming back. And I'm pretty sure I already have another job lined up. So it's just I don't want to feed you a bunch of excuses. I'm sorry. I'm sorry.
That you don't dig the hole worse. If we hadn't had this talk before, and if I hadn't got a report that talks about even minimal compliance, we might be having a different conversation, but that's where we are. So I think I do need to set you as soon as I can so that we can readdress the bond, because right now it's a no bond hold until we see you again. So Ms. Mayfield, can I add Ms. Orozco on Tuesday from the jail with the idea that VRA gets done between now and then?
Yes, I will I don't know that I'm going to be able to be here, but I will make sure that someone is here.
Thank you. So Ms. Orozco Rippin, I'm going to have you cooperate with the deputies who are behind you. I'm going to see you again on Tuesday morning because you're entitled to have a bond reset at that time. Mr. Gardetto, obviously, Ms. Orozco is not going to be able to fill out your application, but maybe on Tuesday, somebody from your office can talk with her. And it is no bond at this time because VRA needs to be made, and it's a verbal motion right now, but Ms. Mayfield, you're going to follow up with something in writing so the record's complete.
Have it done this afternoon.
Thank you. And it can be really brief. You don't have to outline a ton of stuff. I just want to make sure that there's something in writing.
I still do the notarization and.
I don't think you need to do that.
Okay.
Am I allowed to make a phone call?
We'll see.
It's up to the deputies, Kay. Thanks.
Security football.
Trying to track down your attorney, and we have her on WebEx now. Ms. Began, I see you just popped onto the WebEx. Ms. Doyle is here in the courtroom. I'm going to hit your unmute because I can only see the word for your name. Are you there, Ms. Began?
I am. Can you hear me?
I can.
And I'm sorry, I'm trying to turn my camera on. I'm racing your way. Judge, I pulled over. So I can keep coming up. I was in Denver County Court. I apologize. I had Ms. Doyle next Friday. I think the confusion for me is we were in your court and then we went out and she shared with me she's the victim in a different felony case in Boulder with a different DA, and I was out the hallway talking, and I think I reversed it when I put the dates in my calendar. I can keep coming that way right now. I'm just pulling up. I was coming up on 36.
Let's have you stay there for just a second while I talked with Ms. Mayfield or Ms. Joyce about what we're likely to accomplish this morning.
Okay.
Ms. Mayfield, we referenced issues with CJS compliance. Is this going to be a similar situation where Ms. Began should keep coming?
It is a similar situation. I don't know if Ms. Began wants to be here in person, but yes, I think we have some bond issues here that are continuing.
Yeah. All right. Ms. Began, up to you whether you want to keep coming this way or whether you just want to take the discussion from your car.
I'm happy to keep coming, Judge. I'm sure Ms. Doyle would prefer me to be in person, but I also don't want to put the court out. I did call Mr. Pello because he had been in Boulder, but he is now in Denver. So we were ships passing in the night on that. So if the court has time, I'm just turning on to 36 from 25 where I'm pulled over. So probably about 20 minutes out.
Yeah, let's do it here.
Yeah. Okay.
All right. So I'm going to call Ms. Doyle's case now formally. Ms. Doyle, come on up to the lectern. This is 23 CR 1080.
McKenna
Shauna
Mayfield
Bagan.
for people.
Shauna Bagan on behalf of Ms. Doyle. I'm going to say, Ms. Doyle, can you hear me?
Yes,
Okay, Ms. Teed, I'm going to ask you not to say anything, okay? And I'm going to make a record on your behalf. Judge, I did see the report, and I don't know if the court will recall. Neither Your Honor nor Ms. Mayfield was here the last time we had this situation. We were before Judge Bakke, and there was a covering deputy, and Ms. Doyle had a letter that we had copied that indicates that she has a very severe alcohol issue, and her doctor is very concerned for detox and seizures. I just want the court to be aware of that because we had to alert the sheriffs last time that that was a very real concern, so that they could be cautious with her.
Ms. Mayfield, what action, if any, are you asking the court to take this morning?
I am asking the court to revoke bond and to take Ms. Doyle into custody. I actually was present. Well, I don't recall a time when I wasn't present for something. And it was in front of Judge Bakke. I was present for the past 2 court dates. And I know the court date, 3 court dates ago, it was Mr. Lumbio who was here, and he did ask at that time to take Ms. Doyle into custody because of non-compliance issues. And the last court date, I believe, or actually back in November, we were hoping that he was going to take this time to get into compliance and get sober. And I certainly understand the concerns that Ms. Bagan has brought up, but it at this point, it's a community safety issue. If she cannot stay sober, I really don't think I or the court has another option. It's been a continuing issue.
And Judge, let me clarify. I'm not asking the court not to take her into custody. That is when she went into custody the last time. I just wanted the sheriffs to be aware of the safety concern. I don't know that she has a letter this time, but I can get a copy of it. We did send it with the sheriffs last time. And Ms. Doyle, I will come and see you at the jail, either later today or tomorrow.
yeah,
If the court-
fine.
But I don't want you to say anything on the record, okay, Misty?
Can I reset the bond amount and conditions today since it's not a VRA case?
I think you can.
Okay. So let's talk about that now. Ms. Doyle, I credit you for being here today. I assume that you know that bond hasn't gone well and that you knew there was a likelihood that the court was going to take you into custody today.
No,
You didn't know that?
no, I go to everything that I'm supposed to, and he's even taken me off. He's like lowered the times that I go in because I'm doing good. And really
Misty,
good.
Misty, can we
Yes.
hold on? Yeah, let me explain. Judge, Ms. Doyle's on municipal probation out of Longmont. This has been an ongoing conversation. She's not tracking that. Municipal can't share with county. So her municipal probation officer has been modifying. The pretrial services has told her she could go test at the courthouse in Longmont for free, and she has to report there between 8 and 5. She continues to go to the municipal court, and they're not testing, and they can't share the tests. We've talked about using a watch instead or some different form of monitoring. As an officer of the court, I'm concerned that if you were to do a test right now, there would be issues.
She's drunk right now.
I think at this point I have an adequate record from the CJS report that I need to take action on Ms. Mayfield's verbal motion to revoke bond. And so I am going to revoke bond at this time. Ms. Mayfield, Ms. Doyle, that does mean that you're going to go into custody today. I'm looking through all the records and trying to figure out if there's anything I can change with respect to a method of testing for community safety prior to release. And
I'm sorry.
I'll take your suggestion on that. Thank you.
I think it, sorry, I have the wrong notes pulled up. It looks like we were It looks like the bond ordered in November was real-time alcohol monitoring set up prior to release.
Yep. And
So-
the complaint says that she has scram, but is on the verge of cutoff for non-compliance. And so
I don't know what else.
I don't know either. Ms. Doyle, I think Ms. Began's going to say, don't say anything further.
Yeah.
I think at this time, I'm just going to reset with a $30,000 cash surety property. And so revoking the previous bond, which was $15,000 with the cash option that was set in November. Ms. Doyle, I think you posted that bond yourself, and so you're entitled to post the difference if you want to leave that cash bond toward this. I'm not going to do a cash option at this time, though, because I think we need to get serious about talking about where the case is going and what's realistic to assure community safety under the circumstances. Ms. Began, any requests about when I reset it? I simultaneously understand that Ms. Doyle's probably not likely to bond under the circumstances, but also I think we've kind of run out of community safety options at this time, so I don't really want to see the case again and again,
right?
Just to keep having the same conversation.
Right. Judge, I think, I'm trying to think of how to say this delicately. Once we get past the safety concerns of seizures at the jail and we have a period of time, I can have different conversations than I've been able to have to this date. So I do think the next date I will know if we're setting for motions in trial or having a resolution, but I need that period of time to have passed. So understanding that, I'm thinking 3 weeks perhaps. I just don't know if 2 weeks will be sufficient.
Okay. We'll set for 3. And Ms. Doyle, I'll let you know that if this shakes out differently.
Well, I got tested because you're going to throw me in jail anyway, so you can test me.
Yeah, I think we're past that at this point.
So you're saying I'm guilty and I'm not.
I'm going to see you about 3 weeks from now. Ms. Began says she's going to come out and see you at the jail sooner. And if it turns out that you can have a conversation between the two of you where it makes sense to come to court faster than 3 weeks from now, we can do that. So, Ms. Began and Ms. Mayfield.
Just a heads up, they've got another meeting.
March.
To Courtroom Charles.
21st. It's a Thursday morning.
Yes, if that works for Ms. Mayfield, I can do that.
Okay. March 21st. And
That Ms.
Officer,
is the victim of.
the concern that Ms. Began was trying to make sure that the deputies knew about is the possibility of a pretty serious medical withdrawal in custody. Perfect. Thank you.
The second one was a little weird for me because it didn't look like her lawyer was like advocating for her freedom at all, not even a little. And that's very responsible. It just is very responsible. But since when do we know defense attorneys to be responsible in any way, shape, or form? I mean, but she'll get some help in there. Her lawyers set it out for 3 weeks at least. So, she needs help. They both needed help. So, there we go. Let's move on. Let's move on to the next one.
Will be the truth.
Yes, sir.
State your name for the record.
Ashley Nicole Russell.
You can put your hand down. Show the defendant appears in person from the Elkhart County Correctional Facility and by her attorney, Mackenzie Bowling, both by WebEx, State of Indiana, in court by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. Alleged violation of Michiana Community Corrections. Go ahead, Ms. Bowling.
Yes, thank you, Your Honor. We are ready to proceed with an admission. Thank you.
Okay.
That's fine with me.
I think this is also a violation of probation. I think it's both, if I'm reading this correctly.
Here, so Judge.
Yeah, so do you need to send something? Do I need to send something? Yes, I'll send it. Fine with me. Okay. Should make them drug court.
Shoemaker doing drug court? Yes. Well, he's doing the screenings for drug court. I don't know.
He had a 9-hour docket on Friday when I got this, or Thursday, I don't remember. 9 hours long.
They could both come in. Did I try? What happened?
Okay, Ms. Russell, your attorney has indicated that you want to admit that you violated your alternative placement at Michiana Community Corrections and also probation this morning. Is that correct?
Yes, Your Honor.
Before I can accept your admission, I must make certain that you understand your constitutional rights. You have the right to have the state of Indiana prove any alleged violation by preponderance of the evidence. You have a right to have a trial in open court. At that trial, you have the right to be represented by counsel. You have the right to call witnesses to testify on your behalf. You have the right to confront and cross-examine any witnesses called to testify against you. At all times, you have the opportunity to consult with an attorney. Are you telling the court that you understand your rights, you're waiving those rights, and that you're admitting that you violated your placement at Michiana Community Corrections and your terms of probation without a trial?
Yes, Your Honor.
So I'm looking at this, and it appears to me that the main parts of this are that you used alcohol while you were placed at Michiana Community Corrections. Is that correct?
Yes, Your Honor.
You knew it was against the rules of both probation and Michiana Community Corrections to use alcohol while you were placed there, correct?
Yes, Your Honor.
The second part of this is more troubling. It indicates that you left your placement at Michiana Community Corrections and failed to return. Is that correct?
Yes, Your Honor.
I mean, that's what I would call escape. Is that what you look at as having done?
Yes, Your Honor.
Ms. Bowling, any additional questions you want to ask?
Not the factual, Judge. Thank you.
Mr. Pitzer?
No, thank you.
Court finds the defendant waived her rights and her right to trial and admitted violating the terms of her placement at Michiana Community Corrections and being on probation by using alcohol and by failing to return to Michiana Community Corrections, more commonly known as escape. Arguments, Ms. Bowling, go ahead.
Thank you, Your Honor. As of yesterday's date, Ms. Russell will have 1,946 actual days.
I got her
towards
at
this.
48. I got her at 1,948. Did I do the math wrong?
I would trust your math judge, but for whatever reason, I appear to
Hang
be
on a
2
second.
days off.
Mr. Pitcher, you want to weigh on this? I got 1,948.
I would go with your number.
Yeah, and here's the other thing. And in addition to that, she's got 363 educational days. That's got to be added in on an abstract. I don't know that we perhaps care so much about that, but trust me, Ms. Russell cares about it, and DOC cares about it. Go ahead, Ms. Bowling.
Yes, certainly. And I was going to mention note that as well for the court, but thank you, Judge. Additionally, Ms. Russell has been deemed eligible for both electronic monitoring and work release. We are asking that the court sanction her to an increased level of supervision for work release at Elkhart County Community Corrections and allow her to serve the remainder of her sentence there. Thank you, Judge.
Mr. Pitzer.
Thank you, Judge. Without looking at this deeper, I'm just suggesting that you follow the recommendation of court services, which is that if she's found in violation, her probation be revoked and suspended sentence imposed.
Thank you. I'm going to give you a chance to talk, Ms. Russell, because I don't always do that on violations. I'm going to give you a chance to talk, not because I want to hear you drone on forever. I want you to be really specific on what you want me to do and why.
Okay, Your Honor, I'd like to get another chance. Going to the release would probably be a good thing for me. I have served a lot of time. I'm very regretful for the mistakes that I've made while on MCC. I just hope that you can find in your honesty to forgive me for my failures, you know?
You went through recovery while incarcerated at the Department of Correction, correct?
Correct.
So give me an idea. What was the reason for the relapse? Let me hear that.
I was just going through a lot. I had a cousin commit suicide, and that's part of my reason. I know it's not a good reason, but we grew up like sisters. So that was something that triggered me, and the fact that I signed over my youngest son to my ex-husband. So not seeing my 6-year-old in about 5 years, I mean, it's not an excuse, but it's what I'm gonna stick for.
Here's the problem, Ms. Russell. So, you know, when you tell me, let me have one more chance, you know what I hear? I hear an addict talking. I mean, that's just classic. I don't think you disagree with that. I think you've already admitted to me you're a recovering addict, and the question is, you know, are you going to stay on that, or are you going to relapse and fall back into your addictions? What I'm really troubled by is this escape, because now anything I do looks like I'm rewarding your bad behavior, and I almost never do that.
And we've seen this judge before. He follows the law, period. So when he says he almost never does it, he never does it.
I'm going to do what I generally do, and I know you're not going to like it, but I'm going to do what I generally do, which is this. I'm going to revoke your alternative placement on community corrections and revoke your probation. So I'm revoking all of it. I'm going to reimpose the remainder of your 9-year executed sentence, and the 3 years of probation is now executed. So you've got a remainder of 12 years to do at the Indiana Department of Correction. I'm going to order you into recovery while incarcerated. I'm telling you, if you successfully complete that and you have no conduct violations, I will consider modifying your sentence. If you go down there and you do not complete recovery while incarcerated, you have conduct violations, you're going to sit there for the remainder of the 12 years. We'll see how you do. I want to get you back on the road to recovery and keep you there. Cause coming on for hearing on alleged violation of Michiana Community Corrections and probation. Defendant appears in person from the Elkhart County Correctional Facility and by her attorney, Mackenzie Bowling, both by WebEx, State of Indiana in court, by Deputy Prosecuting Attorneys Don Pitzer and Kathleen Clays. Defendant waives her rights, waives her right to trial, and admits violating the terms of her placement on probation and at Michiana Community Corrections. Specifically, the court finds that the defendant used alcohol and escaped from Michiana Community Corrections or failed to return to lawful detention. Court hears arguments as to disposition. Court now revokes the defendant's alternative placement on Michiana Community Corrections and revokes probation and reimposes the remainder of the 9-year executed sentence and the 3 years of probation, so that the defendant will serve the remainder of her now 12-year executed sentence at the Indiana Department of Correction. Court orders the defendant immediately placed in the recovery while incarcerated program. Court will consider a sentence modification upon the defendant's successful completion of recovery while incarcerated and provided that the defendant has no conduct violations. Defendant given credit for having served 1,948 days in actual custody, plus good time credit, plus an additional 363 days of educational credit awarded by the Indiana Department of Correction. It is so ordered. Mr. Pitzer, did you want me?
No, thank you.
Yep, Cloud, you're right. She made a bad choice that day. Choices. She made some bad choices that day. I didn't hear why she got 12 years to begin with. I don't know if I missed it or they didn't say. I didn't hear it anyway. So she got 12 years, not for, that's pretty bad. So she did something pretty bad. And, probation is just the alternative to jail. It's still jail. It's just jail on the outside, and she didn't follow the rules. So I think that she will go through the programs that they have in the jail just fine, and she'll go back before him, and he'll release her again. I just don't know when. I don't know how long it'll take. All right, let's move on to the next one.
I'm good. Go.
We're good. Thank you, and thank you to Denver. Okay, and then we're going to call Mr. Hoffman's case. Okay, thank you. And Mr. Hoffman is with us in 24 CR 248. Can someone let Mr. Hoffman's attorney back into the courtroom?
Let's still go on.
Mr. Sullivan's all done. Thank you, Deputy.
Thank
We
you.
appreciate your patience.
Well, thank you.
All right, and Mr. Hoffman is with us. Counsel, enter your appearance, please.
Good afternoon, Your Honor. Carrie Bell appearing on behalf of Mr. Hoffman, who is present in custody.
Okay, thank you. And Ms. Gatto, you're here for the people?
I am, Your Honor.
Okay, thank you. The court is aware of the facts of this case. No discussion needs to be made. The court has reviewed the CPAT and the recommendation, which is really, I believe, for a PR bond. What is the people's position in this case? Oh, and before I get to that, Mr. Hoffman, the court has issued a mandatory restraining order. Do you understand and acknowledge that?
Yes, Your Honor.
Okay, thank you. All right, Ms. Gatto?
Thank you, Your Honor. Based on the charges, I'm asking the court to set bond in the amount of $30,000 secured, no contact with the victim, no drugs, no weapons, and no alcohol being conditions. Thank you.
Okay, thank you. Are there any particular aggravated? Nope, don't tell me. Okay, go ahead, counsel.
Your Honor, the allegation in this case is more than 10 years old. Mr. Hoffman has no criminal history of any kind since then. There's no allegation of him having any contact or involvement with the accuser during that time. He has a clean criminal history before then as well, with the exception of one 2007 DUI where he successfully completed probation.
Okay.
He has a CPAT score of 0, as noted. He's in the lowest criminal history category or risk category in this case. He has strong family ties here in Boulder. He and his partner Carissa just had a son. He's 4 months old. His name is Duke. And his partner Carissa is here in court today to support him. Mr. Hoffman has been in Colorado for approximately 20 years at this point. He launched his business here in Colorado about 15 years ago, and he's been running it out of Colorado ever since. It is a life sciences consulting firm. He consults with both the Colorado state government and the federal state government. He currently lives with his partner, Carissa, but he owns the previous 2 houses that he had while he was living in first Westminster and then Denver. As I mentioned before, no criminal history. He's 43 years old, and the allegations in this case are more than 10 years old. The bond application reflected that, and I think we both interpret it the same way. And given that how much time has passed and that nothing has happened since then, there is not a risk to the community here. He's not a flight risk for the reasons I stated before, all of his strong ties to the community. So we would request a PR bond in this case.
Okay, thank you. I'm going to issue the $30,000 secured bond with the $300 cash option, no contact with the victim. You'll be back here for filing of charges at 1:30 on February 28th, back here at the jail. And then if defense wants to raise bond again at that time, they may. $3,000. Thank you.
Thank you, Your Honor.
Okay, thank you.
Colorado's not messing around. I think that's Colorado. Could be Indiana. Nope, it's Colorado. That guy was squeaky clean. This offense was 10 years ago. He hasn't done anything wrong in 10 years. Who even knows if this is going to go anywhere? Because 10 years ago, are those people still going to come to court? Are they going to be able to prove it? She gave him a $30,000 bond. $30,000. I barely see murderers get $30,000 bonds. She gave him a $30,000 bond. They're not playing around today. They're just not. Okay, this next one is not funny. It's just more like showing us. I mean, we watch these cases and we see these people, do bad things, really bad things, and we're like, okay, send them to jail. Well, they're still there when they're in jail, and they're still acting the same way in jail and causing the jail lots of problems. And we don't have the best mental health facilities in jail to help the jail out with these people, and this is one of them.
Let me pass on the Howard matter. Let's call People versus Page Singh. Deputy, it's Judge Mulvihill. Do you still have Ms. Singh there?
Yes, Your Honor. Thank you.
All right, thank you. People versus Page Singh, 23 CR 1065, 23 CR 1836, 22 CR 1261, 22 CR 1585, 22 CR 1584. People versus Page Singh. Can I have the appearance of counsel, please?
McKenna Mayfield for the people.
Benjamin Greenberg for Ms. Singh. I would also note we have a couple people on WebEx tuning in today. V. Singh is Ms. Singh's mother.
Okay.
There are several representatives from Imagine and several representatives I see from the host home whose letters I attached to the motion I filed that's pending.
All right. Good afternoon. Good afternoon to everybody. And hello, Mr. Greenberg. Nice to see you again.
As well.
So the matter is here on a review on restoration services, and with respect to the CDHS availability of those restoration services, Ms. Singh is still waiting. The defendant had filed in each of these cases a motion for outpatient restoration. And I'm assuming, Ms. Mayfield, you've had a chance to review those motions and the specific request?
Yes.
What is the people's position regarding that request for outpatient restoration?
So, Your Honor, my position has been basically the same for the entirety of Ms. Singh's cases, and that is that she's just not safe in the community. She has picked up, I think it's 6 cases now each time that she gets out of custody.
I've got 5. Is there a new one?
There should be a 6th.
That one's still down in county court, although that one was picked up in custody to be.
Okay.
That one's set for review in a couple of weeks.
Okay. Did they find her incompetent in order restoration?
Correct, all the same things as Judge Salamone found previously.
And I'm sorry to interrupt you, Ms. Mayfield. Please continue.
I also would point out that each new case has some kind of violent allegation. Frankly, Your Honor, we've, I think, had multiple 45-minute to an hour-long bond hearings on these cases. And my position just remains the same. I don't want her to have to remain in custody because it's very clear she's not doing well. But at this point, my focus is community safety, and she just is not appropriate to be in the community. I'm happy to try to get into more detail for the court. And
well, I'm familiar with the history, at least with respect to the 5 pending cases on today's docket. I haven't looked at the 6th case, but to the extent that it involves assaultive or violent behavior, it is unfortunately a continuation of what we've seen from the initial filing through. This is a really, really sad situation because Ms. Singh is desperately in need of restoration. And I understand the people's concern about community safety. And frankly, I think that position is well taken. I appreciate defense counsel's efforts to find an alternative to the otherwise formalized process for restoration that applies through CDHS. And I appreciate the good intentions of those people that were willing to have Ms. Singh in a facility outside of the county jail. And I'm also mindful of the fact that it has been very difficult for the Boulder County Sheriff to manage Ms. Singh while she is in custody at the jail. And I particularly am concerned about the impact that continued incarceration without restoration is having on Ms. Singh. Having said all of those things, I think that the concerns raised by the district attorney are legitimate. And I don't believe that the plan for outpatient restoration adequately protects the community from Ms. Singh while she is in her present state. I wish the answer were otherwise, but I can't find that it would be appropriate to have her released from jail, even under the structure that was proposed by the defendant's motions. And I recognize that means that Ms. Singh will remain in custody until such time as they can find a bed at the state hospital to administer restoration services, and all of the difficulties that I just spoke about will continue. But she's frankly too dangerous to have out of a officially contained setting, for lack of a better term. So I'm going to respectfully deny the motions for outpatient restoration. We'll need to set the matter for another review hearing. Typically, we would do that on a 60 to 90 day time frame. I'll look for a date that's closer to 60 days to the extent that has any impact at all on CDHS's consideration and prioritizing of the case. All I can do is hope. Mr. Greenberg, I've got Wednesday, May 1st at 8:15 or Friday, May 3rd at 1 o'clock.
Let's do the 3rd at 1 o'clock if that works for the people.
Does that work for the people?
I'm sorry, I missed the date.
May 3rd at 1 o'clock?
May 3rd. Yes, that is fine.
All right. All of these cases are continued to Friday, May 3rd for a continued review on restoration to competency. And we'll have the sheriff facilitate Ms. Singh's appearance either in person if she's willing, or virtually if she is not. Thank you.
Thank you, Judge.
I don't think the jail was able to hear what the judge was saying because she was pounding on the door. He was trying to get his ear down there, but yeah, the only thing they can do is wait for a state hospital bed, and you know they're full. They're just full. Judges now are just so hesitant to schedule any type of competency eval because they're months out, because there's just so many competency evals and there's so many people who want beds. And this jail right here, they're struggling to handle her because she's violent. And the judge doesn't want her in there anymore. You know, he wants her to get the help that she needs. They think that that they okay, so sometimes the cases are just completely dismissed if you are mentally incompetent and they think you can't be restored. So if you're mentally incompetent and you cannot be restored, they dismiss the case and you're free to go. But she can be restored. They think that she can be restored. So she's violent. She's a violent person, and she's stuck in there until they can find a bed. There's nothing else that her poor mom is there, and there's nothing her mom can do to help right now. They're just waiting, and the poor jail has to deal with it. But Cloud Illusion says, one thing about Colorado courts is they have light colored wood. And it's so true. There's this court in Indiana that I wanted to get. I wanted to get some cases from there. But it's so dark. The wood in paneling in the courtroom is so dark that just the judge is like illuminated. And everybody else is in darkness, pitch darkness, and it looks like hell. Like, it just looks like hell. So I just don't watch it. I get bored. I don't know. I can't focus. I can't sit there and, because some of these cases are really boring. So I go through a lot of boring ones until I find one that's not boring. And I can't go through all those boring ones with that dark wood. I just can't do it. Maybe I'll try on Monday. I don't know. Maybe. We'll see if I can get that court. So you'll see what I'm talking about. All right, guys. Thank you so much for coming out today. Appreciate it. I do. And please remember, be quiet. Do not interrupt the judge. Be quiet. All right. I hope you guys have a great Sunday. And I'll see you again soon.